Hi everyone, my name is Dylan Grant and welcome to part 4 of my presentation on Nicolini Law Firm False Statement of Claim. Okay, as I did indicate before that for the first 2 slides you will see the same thing throughout from part 1 up to part 6. Okay, it's just the beginning on what I am actually talking about. I had no contract with Adrian Nicolini Law Firm, and this lawyer misrepresented me. Okay, please feel free to pause and read if I'm going too fast. Okay, and I do hope you understand what I'm trying to say and get the picture that this lawyer Adrian Nicolini and Ashlyn Steele, both of Nicolini Law Firm, did me wrong. Okay, please feel free to pause and read. Thank you much. Statement of claim, wrongful dismissal, and long-term disability created by Adrian Nicolini and Ashlyn Steele. They are both of Nicolini Law Firm. It was done without my consent or involvement. We're still on 2019. Okay. May 2019, part 2 of 2. Okay, I saw Adrian Nicolini on May 2nd, 2018 as my WSIB lawyer, right? For reasons below. I received my first warning letter from the ability to return to work and to provide him with the updated ultrasound of my injury dated May 1st, 2018, right? Adrian Nicolini stated on the docket sheet that he saw me on May 2nd, 2018 to discuss the status of my claim and next step. What claim was he talking about? Okay, I wasn't even denied as yet by long-term disability. That letter I eventually received from Industrial Alliance, right, was dated May 8, 2018. All right, I was still employed at Mobility, which would have been premature for a statement of claim long-term disability. Okay, please feel free to review. May 2nd, it says meeting with client to discuss status of claim, next step. Okay, not sure what this was all about, but Benjamin Law, right, was charged. Okay. In May 2018, Adrian Nicolini received an email from one of the Bell lawyers after Adrian Nicolini had sent an email to my supervisor to state that, I cannot return to work, and also that he is in agreement with Dr. Silverberg. Okay, so when Adrian Nicolini sent it to my supervisor, who was Albert, Bell lawyer responded. Nicolini Law Firm did it again. Instead of informing me and advised that I attend his office for my signature, I was unaware once again of an authorization form. Okay, my signature was forged again by Nicolini Law Firm. It's partially hidden because it was close to my signature. All right, so here, Ashlyn Steele. This is Ashlyn Steele's signature, and whosoever forged my signature. Okay, and again, September 7, 2016, I would not have. This is if it's about employment law. I would not have stated September 7, 2016. Okay, please feel free to review. Thank you. All right. Here's information here that it was copied. Adele Belzile from Manulife Insurance had copied Adrian Nicolini, okay, saying that my absence from work was not authorized, okay, after they had Manulife had violated my rights by getting an assessment firm to override my decision, right? They did everything. Oh, they did it for me. I didn't have. It's like I didn't have any right in this country, none whatsoever. If I say no and they believe it should be yes, they're gonna ensure that it's a yes. Can you imagine? Okay. So after this email, I received this letter from Bell, April 27, 2018, saying that my absence from work is unauthorized and I have to return back to work, required to come back to work on Wednesday, May 2nd, 2018 at 8:30 at your regular work location. Dr. Silverberg stated if they need me, if they want me back at work, which, well, I shouldn't be, but if they wanted me back, they kind of put me back at my regular position. But they were insistent. Okay, please feel free to pause and read. Thank you. And this is when I got an ultrasound. Okay, see, after I got that warning letter, I went to Great Lakes Medical Center. Okay, and they did. I sent. They had sent me for an ultrasound again. Okay, at the imaging center, and here, as you can see, May 1st, and it still states tenosynovitis. Okay, as you can see, please feel free to pause and read. Here is a letter that my Ada Nicolini had sent to Albert, my supervisor. Okay, stating that Miss Grant, it says, as you are aware, we have been retained to represent Miss Grant with respect to her injuries arising out of her disability. Yes, as my WSIP lawyer, right? We are in receipt of Bell's correspondence dated April 27, 2018, advising that Ms. Grant is required to come back to work on May 2nd, 2018 as her regular job, right? At her regular job. We disagree with Bell's position. Okay, see that the lawyer said that, WSIB lawyer said that, Adrian Nicolini said that. Okay, in fact, Miss Grant's treating specialist, Dr. Silberberg, has confirmed that a return to a regular position will only serve, to worsen her medical condition. Dr. Silverberg further noted Ms. Grant's restrictions include an inability to use her right hand, respectively, and are indefinite. For the sake of completeness, we have enclosed Dr. Silverberg's facts, dated February 10, 2018, and confirming the above. So I wasn't making up stories. There's proof, okay? There is proof, and then information here was attached. I see your notice of change, right? Notice of change. I guess maybe wasn't paying much attention, but I guess this is where they had forged my signature. I think this was it. Okay, please feel free to pause and read. Thank you. Okay, this is the same letter. All right, May 1st to my supervisor, right, that I just read. Okay, however, in response to that letter, a response came from Jessica Reed on May 3rd. Okay, stating that, dear Mr. Nicolini, I am acting as counsel for Bell, and I acknowledge receipt of your email below sent on May 1st, 2018. I will investigate this matter and provide you with company's position soon. In the meantime, please do not hesitate to contact me, blah, blah, blah. Okay, so Adrian Nicolini sent it to me to say, please see the attached correspondence. Please feel free to pause and read. Thank you. And here I sent this letter to Adrian Nicolini on May 3rd. Okay, I saw Adrian Nicolini on May 2nd. Luckily, I did that, Okay, I said, thank you for seeing me today, May 2nd, 2018. And you see that notice of that authorization when my signature was forwarded was dated May 1st. Okay, this letter was sent on May 3rd because I took my time, my left hand, to type. Therefore, there was a delay. Okay, so instead of this letter being sent on May 2nd, it was sent on May 3rd. Okay, there was something regarding the job posting. I was just letting him know certain things. This is just proof that I did not see Adrian Nicolini on May 1st. Okay, 2018. Feel free to pause and read if you wish. Thank you. And here, this is what was sent to my supervisor, right? This was what was included when he made mention that when the Dr. Silverberg had faxed him the report. This was the description of functional abilities, that I am incapable of going back to my job. Here it says there is no, Dr. Silverberg stated, there is no medical treatment that can heal an injury. She injured herself performing her job, and the pain will increase if she returns to that job. And they keep saying, I must return to my regular position. What would you have done? Would you override the doctor that actually understand your situation and follow your workplace? Yeah, your job is important, yes, but your health is also important. Would you have ignored your doctor's requests? Here he's telling them, I cannot go back to that job. So would you have gone back? Okay. As a matter of fact, if I had gone back, right, I would have override this decision by the specialist, and Bell would have fired me regardless. They were setting me up to be fired, as you can see from my previous presentations. Okay, that was the intent. All right. Here, please feel free to pause and read. Okay. June 5th, as you can see here, June 5th, right? I was not retained by Nicolini Law Firm for long-term disability. June 28th, it says drafting statement of claim and scheduling process server. On June 28, 2018, where was my copy of the drafted statement of claim for my review if one was completed? If it wasn't for this docket sheet, I wouldn't even know that I wouldn't know anything about the statement of claim. You understand? If I didn't retain this lawyer, why is he drafting the statement of claim, right? Then why wasn't Benjamin Law charged for the statement of claim dated July 3rd? If the statement of claim was created for July 3rd, that's the date of the statement of claim, okay? Why wasn't Benjamin Law charged? If there was a response letter from Money Life Insurance dated July 17, 2018, it too must have been backdated to cover up deception, right? I'm not sure how they did this, but definitely they were doing me wrong. They were doing me wrong, okay? On August 16 here, it says review statement of defense, the Industrial Alliance Insurance and Financial Services. On August 16, 2018, if a statement of defense had existed, why wasn't I, the client, given a copy also for review, right? Isn't it my case? I'm supposed to know about my case. The lawyer don't know anything about me, okay? Be free to pause and read, okay? Thank you. All right, so you can see here, please feel free to review the deception of Nicolini Law Firm without my involvement, create a statement of claim for long-term disability, okay, against Money Life Insurance, which was incorrect. If I had, and I'd made mention of this already, I've showed you this already, right? Because Adrian Nicolini submitted something here to Manulife, right? On July 17, 2018, Manulife had responded to state that they did not, they only were short-term disability. They were only for short-term disability for mobility, right? Not for long-term disability. So Manulife Insurance here, Joanna Board, was making it clear that they cannot be sued for long-term disability when they only served Bell Mobility for short-term disability. I already knew that, but this lawyer didn't know, so it was making a mess of my situation, eh? So basically, Manulife was denouncing whatever was going on in this email, in this letter. I've already addressed it in my previous presentation, okay? Docket sheet dated August 16, 2018, review statement of defense for Industrial Alliance Insurance and Financial Services Income, addressing that, right? This was for long-term disability, right? 2, why would Nicolini Law drafted statement of claim for the Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Service Inc. and did not provide a statement of defense also for the Manulife for the manufacturer's life insurance, short-term disability, and if damages, and for damages. 3. Why would Nicolini Law issue a statement of claim without both companies and only drafted statement of defense for only one company? Okay. As you can see, it says here manufacturers, insurance company, and industrial alliance insurance and financial services, right? Inc. This is statement of claim. So here, why would he, Adrian Nicolini, that is, okay, only draft a statement of defense for industrial alliance and financial services? That's what my question is. Can you see that? August 16, it only have here one statement of defense for industrial alliance insurance and financial services, while a statement of claim is saying the manufacturer's life insurance, two companies, but only one listed here. Please feel free to review. Okay, anyone can answer that. If this docket sheet was legit, why didn't the responses to the following two letters, September 18, 2018 and December 17, 2018 for Money Life Insurance, appeared in the list of activities which Nicolini Law Firm stated was for long-term disability claim between July and December 2018? I had retrieved the following two letters from the motion that was filed against me in 2021. Okay, so as you can see here, there's no September, there's no December 17. Okay, please feel free to pause and read. I'll go on the next slides. Okay, so these two I received from the motion, and here they're communicating. Adrian Nicolini was communicating with Money Life Insurance, and as you can see, Money Life Insurance responding on September 18, 2018, right, regarding, say, please find the notice of intent to defend the manufacturer's life insurance company, which is served on you pursuant of the rules of civil procedure. Okay, and then on December 17, 2018, still to Adrian Nicolini, right, from Money Life Insurance, it says, further to my letter of July 17, 2018, I confirm that manufacturers Money Life's involvement, right, in relation to disability claims brought by Bell Canada employees relates solely to administering short-term disability claims on behalf of Bell Canada. So you see what's going on here. Okay, they in December 17, they're still confirming that we cannot sue them for long-term disability because they only deal with Bell Mobility and with short-term disability. As I said, I already knew that. Be free to pause and read. I did some doodles here. You understand? Like 1, whose signature is on the statement of claim? Whose signature? 2, I was unaware that Nicolini Law proceeded to solicit on my behalf without a contract. Okay. 3, shouldn't I receive a copy of this letter or statement of defense? 4, deception. Okay. On the December letter, I doodled. 1, Nicolini Law was intentional to have opened a claim on Money Life for long-term disability. 2, deception. 3, my claim on Money Life is not for long-term disability, right? But 1 month short-term disability and for damages. All right. I had provided proofs to Nicolini Law, but the firm did otherwise. 4, now I know why I was not included. Okay. Appointment from the Nicolini Law Firm for October 31st, 2018. Reason for the appointment was WSIB, okay? Rose, an injured worker at Mobility from my department, had requested to see my lawyer re-advise on her injury, right? An appointment was made prior to my knowledge that my claim was suspended, okay? As you can see here, you see October 31st, 2018, this lawyer wasn't Benjamin Law should not have been charged because this meeting did not belong to me. The October 31st meeting belonged to my coworker, and I have proof to show you. Okay, my coworker Rose. It says here, meeting with client to discuss the status of her claim and next steps, corresponding with both defense counsel requesting direction of action and consent to amend the statement of claim. And I have proof to show you that October 31st was not about me. Okay, plans were made prior to October 31st 2018 to accompany my co-worker Rose to see Adrian Nicolini read WSIB. I became aware that my WSIB claim was suspended in the month of October 2018 after the appointment was with Nicolini law firm was already made. The appointment was not for me, but for my co-worker Rose. I took the opportunity after to ask Adrian Nicolini about my suspended WSIB claim, but was told they would take care of it. No explanation on why my medical reports from the doctors were not provided. Okay, Nicolini law firm at no time advised that they had begun work on my wrongful dismissal on long-term disability claims, especially without a signed contract. So this here falls. Okay, you and I have proof. Conversation between Adrian Nicolini, WSIB lawyer, and I regarding a consultation for Rose, my co-worker. The appointment was made for October 31st, 2018 for Rose, my co-worker at Mobility. Rose had asked that I accompanied her to my lawyer. Therefore, I informed the office that I would also attend the meeting. Okay, so the 27th of September 2018, I sent this text to Adrian, my lawyer, Adrian Nicolini. Good morning, Adrian. I hope that all is going well. Sorry for the typo. I have a co-worker who was also denied by WSIB with both hands injured at Bell and is seeking a lawyer. Can you see her for a free consultation and advise her accordingly? Please advise. Thank you and have a great day. Right? And add other information. Please feel free to pause and read. And then Adrian Nicolini responded, "Hi, Delane, sure, I'd be happy to speak with her. Have her call the office to book an appointment, please." And I said, "Thank you, Adrian. I'll let her know." Okay, feel free to pause and read everything. Thanks. Conversation below between Rose and I began in September 2018, continued on the other slides to make arrangement for an appointment with Adrian Nicolini, which was eventually scheduled for October 31st, 2018. The meeting was only for WSIB. No other cases were mentioned. Rose, okay, from Rose on September 6th of September 2018. This was the CBI. She made mention. That's why I became aware of the CBI report, the one that of our work area, to state that our duties at work is low risk, right? That's what they're saying, and that we have 51% of idle time. Yet here's my coworker injured, and we were not the only ones. Okay, so she said, I got the report from CBI that they used to decline our WSIB claim. You understand? Then on the 7th of September 2018, she said, I'll be meeting the first lawyer I contacted next week. Okay. On the 11th of September 2018, she said, Hi, Delane. I just came from a lawyer's appointment. I have some questions. I hope you can call me back. Right? Conversations went on. Another time, I didn't get the date in this time, but it was in and around September here, right? September, October. This, I believe, that was October, because she said, good morning, Rose, that is, said, texting me, good morning, I got a letter from Money Life that they're suspending my benefits as of October, the 8th of October 2018. I don't know what to do. And then I said, oh my, can I call you? And, please feel free to pause and read. Thank you. Plans were being made to see my lawyer, Adrian Nicolini. See conversation below. Rose, my co-worker, requested to see my lawyer for legal advice. Rose had asked that I accompanied her to see my lawyer. Appointment date was confirmed, this appointment was prior to my knowledge that my claim was suspended. All right. So here I said, can you arrange for, she said, Rose, that is, Rose texted me, can you arrange for your lawyer to see me? Right. And then I responded, should I give them the name Rose, whatever her name, was? And then, and I said, thank you, I'll be calling now. Hang in there. Okay, that's my response. Okay, I gave her the lawyer's number, right? She wanted me to call him instead, so I did. Lawyer's appointment, I told her, right? This was, I was responding to Rose. I said, lawyer's appointment was on October 31st, 2018 at 3:30 p.m. Then the lawyer's office called and changed, and he said, and I in messenger again, I said the lawyer's office just changed the appointment from 3:30 to 1:30 on for October 31st. Okay, as you can see. Okay, then she said okay. Then I said, so new, lawyer's appointment October 31st, 2018 at 1:30 p.m. And then I said I will send the address. Okay, send the address. As you can see, that's where the law firm was. Okay, please feel free to pause and read. Thank you. Then I said, yes, we can. She wanted me to accompany her. Okay, this was her appointment. She wanted me to accompany her. They said, yes, we can, and we can meet at a point, and there be there at the same time. We will plan it closer to the time. She said, okay. Then she told me, Rose said, I applied for EI, and then I said, okay, okay. So on the docket sheet here, as you can see, on January 8, 2019, it says here, telephone conference call with client to provide a status update. Telephone conference, okay? January 8th. So Benjamin Law was charged again for a lie, okay? There was no conference call on January 8th, 2019. I called to inquire about statement of claim as requested by Kevin Marshall Law, which was received on January 10, 2019. As I can see, Ashton Steele, right, on January 10, 2019, has submitted the statement of claims, which I saw for the first time, as you can see here, okay? And on January 8th, so January 7th, I called Crystal, and also on January 8th, I said, here, please listen to a voice recorder on next slide. Is proof that I had only spoken to Crystal Nicolini Law on January 8th to inquire on statement of claim as directed by Kevin Marshall Law. There was no communication, no conference call at all, okay, with Nicolini Law Firm regarding statements of claim or anything regarding employment law. All right, so here's my proof, okay?
Crystal? I'm sorry, agent leaving the office right now because his appointments are concluded for today, so you will be unable to come in. In the future, we do prefer booking appointments rather than having walk-ins. Also, in regards to your claim, it has been issued, but defense counsel did like to add someone to the claim, which is why we're waiting for consent from the other party to do so.
So this was done on December 20th.
It was done around then. We added someone to the claim.
Well, because the thing is, okay. So since May, you're saying that there was a claim open, and then because of some changes, what was it that made the change for?
So defense counsel, the other party, they want to add a party to the claim. So we just added the party recently, in December. So now we have to wait for their consent, but the claim has already been issued.
Okay, so I'm gonna get a new number then.
No, it's going to be the same claim number.
Oh.
So Ashlyn said that she can email you a copy of the statement of claim if you'd like.
Okay, okay, that would be great then. Yes.
Okay.
Yes, that
I
would
will
be
let her
great.
know.
Okay then. All right. Thank you so much, Crystal.
You're welcome.
All right.
Bye.
Okay then. All right. Later. Okay. Bye bye.
Bye.
Thanks. Bye bye.
How was this possible? I retained Benjamin Law Firm on February 13, 2019 for long-term disability. Adrian Nicolini and Hussein Muftaderi sent a letter to Benjamin Law on May 14, 2019, 3 months later, to inform that they were in the process of amending the statement of claim to include Bell Canada. This was actually a criminal act since I never retained Nicolini Law. All this was done without my knowledge or involvement. I was never informed of any amendment, okay? As you can see, Nicolini Law Firm, an intent to deceive, 8 months later retained Benjamin Law on February 13, 2019, okay? And as you can recall, I've been through this where they, on May 14th, they're saying they're in the process of amending statement of claim, okay? Please feel free to pause and read. I've been through this before, okay? The information here, I've enlarged it for you to read. This was all deception given to Benjamin Law Firm, okay? Was this a stall to stop the examination for discovery? What happened next? The examination for discovery was scheduled for August 16, 2019, okay? These two lawyers, Adrian Nicolini and Hussein Muftaderi, intentions were to silence me by any means necessary. They succeeded by allowing the system to gang up on me. Systemic racism, okay? See also presentation on Sanfaruta marking law, which contained details of the deception of Ixmorley law and the Nicolini law within the same month of May 2019. Okay,